Hello viewers and a very warm welcome to this episode of the Indian Lawyer Legal Tips. In recent times, we have been hearing the word impeachment over and over again. It is reported in the newspapers, it is often mentioned in television channels, and of course, repeatedly in social media. Let us understand what is impeachment in India, a constitutional safeguard against the abuse of power. Hello viewers, I am Susheela Ram Verma, Advocate and Chief Consultant with the firm. Let us first understand what impeachment refers to. It is a formal accusation or charging of a public official for either acts of misconduct, incapacity or constitutional violation. To impeach is to accuse or charge a liability upon a public official for certain acts he or she has committed. In India, impeachment is a rare and solemn constitutional remedy to ensure accountability of the highest public functionaries such as the President, the Supreme Court and the High Court judges. It is not merely a punitive action, it's a mechanism to preserve the institutional integrity, public trust and supremacy of the Constitution of India. In this article, we have chosen to examine impeachment of judges of the Supreme Court and High Courts, impeachment of the President of India, and relevant procedures, landmark instances, judicial interpretations, and global perspectives. Now, impeachment of judges under the Constitution of India falls within the ambit of Article 124(4) for Supreme Court judges and Article 217 for High Court judges. Article 124(5) empowers the Parliament to regulate the procedure by law, which has led to the Judges Inquiry Act 1968. Under Article 124(4), a judge of the Supreme Court can be removed only by order of the President after an address passed in each House of Parliament, which has to be supported by a special majority. And when we say majority, it means 2/3 of members present and voting. The exact process again applies to High Court judges under Article 217. Now, what are the grounds for removal? There are two grounds: proven misbehavior and incapacity. The Supreme Court in C. Ravichandran Iyer versus Justice A. M. Bhattacharjee 1995 defined misbehavior as a grave conduct affecting public confidence in the judiciary, such as financial impropriety, moral turpitude or gross abuse of judicial office. Now let us understand the step-by-step process for impeachment of judges. As per the Judges Inquiry Act 1968, the first step is initiation of motion. The motion has to be signed by 100 Lok Sabha MPs or 50 Rajya Sabha MPs and submitted to the Speaker or the Chairman depending on which house the motion has originated. The second step, admission, that is the presiding officer may admit or reject the motion. The third step is formation of the inquiry committee. A 3-member panel is constituted, 1 Supreme Court judge, 1 Chief Justice of a High Court and 1 eminent jurist. Step 4 is the investigation and report. The committee conducts an inquiry. The judge who is going to be impeached gets full opportunity to defend himself or herself. The committee submits a report to Parliament. If charges are not proven, the motion is dropped. If proven, the motion proceeds to vote. Step 5 is voting in both houses. The motion must be passed in both houses with majority of total membership, which is currently 2/3 majority present and voting. And finally, step 6, which is the presidential assent. Upon passage of the 2/3 of the motion, the President issues an order for removal. Now let us see what is incapacity and medical examination. If incapacity is alleged and it is denied by the judge, a medical board will be constituted and that medical board will examine the judge. In case the judge is not ready to get examined by the medical board or is not cooperating, then it will lead to an adverse inference that he is generally incapable of holding the position of a judge. Notable instances of judicial impeachment in India is Justice V. Ramaswamy, who was accused of financial irregularities as Chief Justice of Punjab and Haryana High Court. Sadly, the motion failed in the Lok Sabha due to Congress abstaining. Then you have Justice Soumitra Sen, 2011, misappropriated court-appointed funds. Rajya Sabha passed the motion, but he resigned before Lok Sabha could vote. The third is Justice P.D. Dinakaran, allegations of land encroachment and corruption. Again, he resigned during the inquiry. Justice C.S. Karnan, 2017, made bizarre corruption allegations against Supreme Court judges. He was jailed for contempt by the Supreme Court of India, a first precedent in Indian judicial history. No impeachment motion was initiated. Then in 2018, you had the impeachment motion by 64 MPs for Chief Justice Deepak Mishra's impeachment. This, however, failed and the Vice President rejected it for lack of merit. Currently, in 2025, we have Justice Yashwant Verma, who is a sitting Delhi High Court judgment. He was accused of having bundles of burnt cash found after a fire at his residence. Supreme Court panel recommended impeachment. The process is underway. Now, let us examine the system of checks and balances. In Subcommittee on Judicial Accountability versus Union of India 1991, the Supreme Court clarified that the inquiry stage under 124(5) is a legal process and is subject to judicial review. The voting stage under Article 124(4) is a parliamentary process and it is beyond the court's interference. The two-stage framework balances judicial independence with parliamentary oversight, ensuring that neither branch overreaches. Now, the in-house procedure of judiciary. Beyond impeachment, judges follow an internal code of ethics known as the in-house procedure, which has been adopted by the Supreme Court of India in 1999. It is based on restatement of values of judicial life and it ensures internal discipline, decorum, and transparency in judicial conduct investigations. Though non-statutory, this mechanism plays a preventive and corrective role in safeguarding the credibility of the judiciary. Now let us examine some global perspective on judicial impeachment. The United States. Judges and presidents can be impeached by the House and tried by the Senate. Two-thirds votes required in the Senate. Example, impeachment trials of federal judges and president, that is Donald Trump, in his last term. United Nations impeachment is now obsolete and ministers are removed via political votes or public pressure. In India, the process is long, complex and rarely successful, balances independence and accountability but lacks transparency and efficiency and may therefore not be the best way of removing any highly placed official in the government of India. Impeachment of the President of India is under Article 61 and that is only if he has violated the Constitution of India. Till date, there has been no impeachment of the President of India. Generally, this motion is initiated in either house and signed by 1/4 of total members. The first house passes it with 2/3 majority. Then the second house investigates and hears the president, and the second house passes by the same majority, after which the president can be removed. Now, let us see what are the criticisms against this system. It is believed that this particular system of impeachment is politically influenced. It is too opaque because of the in-house procedures. There is no accountability for minor misconduct, and the high procedural thresholds make impeachment a very difficult action. In conclusion, impeachment in India reflects the spirit of constitutional accountability, but its rare usage and procedural bottlenecks demand thoughtful reform. While protecting the independence of high offices, the system must evolve to also ensure timely action, transparency, and public confidence. In a democracy governed by the rule of law, even the highest authorities must be accountable, and impeachment is a last resort instrument to uphold that principle. I hope this brief overview on impeachment has given you some idea on what the process involves. Let us now wait and watch to see what happens in the Delhi High Court judge's impeachment. He has filed a writ petition in the Supreme Court of India challenging the inquiry, which is supposed to be which is supposed to come up on the 30th of July for a further hearing. If you have found this useful, please like, share, and subscribe. Please help us to reach as many people as we can. This program is only for creating social awareness about the laws in India. We are not using it for any commercial advantage, and we therefore request you in all humbleness to please try and spread news on this channel as far as you can, so that we can reach better and a more bigger section of the society. Thank you. Till we meet again at in the next episode. Jai Hind.